as lawyers and as students, law students. So, in a nutshell, I want to do a short talk because I believe that this is both informative and also educational, and I will expect, especially the law students, to interact, ask questions, and let us have a very informative and learning process today. So, like you already saw, my topic today, it's titled, I'm narrowing down my theme to focus on the audience, law students and lawyers to be, and also professionals, the academia, legal scholars who might find it interesting. So the title is Law Schools and on Academic Originality in the AI era. I mean, you see, because we are scholars, we have kind of license to mess with English words at times. Because I'm sure if you go to Google or Chat GPT, you won't find a word like unacademic. Or, but it paints a picture of the core of my presentation. Now, you see, AI, as we all know, is a disruptive system. If you've listened recently to the news, about 2 days ago, AI interrupted global economy. AI interrupted money. Billionaires had a lot of high blood pressure. People were scared. Government was scared because stocks dropped. A new entrant, DeepSeek, which is an AI system, interrupted the whole situation. I mean, the allegation now is probably there is AI, intellectual property, infringement, and all that, which we're going to talk about. It's part of the talk here. But it shows you how relevant this technology is. How relevant is this technology when it concerns law schools, law students, legal academic, legal scholarship? Now, my topic is focused strictly on intellectual property as it intersects with AI. Now, I'll narrow it down to the issues of copyright. Now, we talked about originality. Now, if you are students of copyright, you will realize that you should know by now that AI is a computer program. Even the Indian law, because India is part of WIPO, American law, Saudi law, globally, computer programs have been recognized as literary works, meaning that copyright is the controlling, I use that word with emphasis, the controlling jurisprudence, the controlling law, the controlling regime that regulates anything that is literary. Meaning, so in the space of AI, there are other laws that regulate it, but I'm talking, when I say control, means at the apex, at the jurisprudential hierarchy, the pyramid, it is copyright that stays at the top. Meaning that until you fulfill the legal requirements of copyright in terms of a literary creation, that is when copyright can either protect your literary work, meaning your legal writing, because legal writing, scholarship, what you're going to publish. As lawyers, we are taught that oral presentation and legal presentation are the blood of a lawyer. I mean, it is your tool. If you are not a good writer, if you are not a good speaker in the tool of your trade, in law, whether you are an academic, whether you are practicing, whether you are a judge, you will find it very difficult to be a successful lawyer. And because law and academic ethics, academic integrity seems to collide, they seem to have a little bit of friction because the law requires that before you're writing, that's copyright law, qualifies as a thing that could be protected, it has to fulfill certain eligibility metrics. And I'm glad that in India has made it even easy, because India seems to follow the global trend in the Supreme Court case, which I'm going to talk about a little bit. I think there's a Supreme Court case in India that has now clarified the standards of originality. DB, Modak, and another. I think it's a 2008 case. So you see, that is how important for us to study and understand that in academia, apart from the fact that you've been given certain privileges as students and as educationists, or as those who are in the academic space, you also have to fulfill the law. So you have the ethical issues of, for instance, they call it plagiarism in the academic world, plagiarism, which is a little bit close to, moral rights issues or copyright issues, but they are different. Plagiarism and copyright, strictly speaking, they are different issues altogether. So you see, you should be able to understand that AI, with its new evolving systems, is problematic. In fact, there are a lot of cases in Europe and America now still going on in the court system for us to even understand the parameters, the jurisprudence, how much is AI protected by copyright, how much leeway, how much license, how much fair dealing, how much fair use, exemptions that you are allowed to scrap other people's data and train them to now become what we now have as large language models, the LLMs. Now, we have the LLMs, which I just spoke about. We have a few examples of the large language models on ChatGPT is a specimen of an AI system. I just mentioned DeepSeek, Stable Diffusion, and Gemini. We have different spectrum of these AI systems. Now, but the problem now is, slide 3 now. The problem now we have is that now AI is like Professor Ryan, one of the forerunners in advocating for recognition, legally recognizing AI and granting AI the same status as a human being in terms of ownership or authorial rights in copyright. AI is looked at as a utilitarian tool, meaning the value, the profit, the benefit that AI has for society may be far. That's the argument of those who want AI to be fully recognized as an author or as an owner. Their argument is that because AI is a utilitarian tool, it has a lot of benefits in the healthcare system, in national security. Even it helps scholars now as law students. You will see that it is easier for you to do research and cheaper. I
heard that people are hating me like crazy. Hating you out there?
No.
Why would they hate you?
Somebody said.
Joel, can you please mute yourself? You don't like it? Can't even sit on. I heard people are hating me. People are hating you, that we both know. Wow. What I told you, no? Carmen. Yeah.
Dr. Joy, can you unmute him?
Yes, what happened was, there was this, my good friend came to me and was like, I told my friend that I'm talking to you. The guy said that, oh, she's crazy. She'll always sit in the first.
Maybe they are not aware. That's okay, thank you. Okay, so like I was saying, so there is this attention that we now as scholars have to filter and make our students aware, because it's going to affect your practice. Now, why is it going to affect your practice? Now, if you, because it is now easy and legal research is kind of a simple, cheaper. I mean, when we were in law school some decades ago, we are not too old though, but it was very difficult to do research. You have to subscribe to most of those expensive companies for you to be able to, do a little research, for instance, about who is a man, But these days, because of this technology, you see ChatGPT and the rest of them, you can easily, without paying a dime, just go to the internet. And that is the benefit of the digital era. But see, because it's free in the internet, you could go into the internet and do what we call copy and paste. Most of the law students as teachers, and my colleagues will testify, students like it easy. They will just go in there and copy, paste, and plug it in and submit the paper, not realizing that apart from the fact that it is not an excellent character, it also infringes on policy and law in so many levels. Because doing that, you probably could have infringed on somebody's literary work, and you probably also would definitely have infringed on the ethical policies of your school. And again, the most important one that I'm concerned about, you would have gone against the professional ethics of legal practitioners in your country. Most of the countries of the world have similar rules of conduct, code of conduct for lawyers. I mean, I have studied a lot of because I've worked in about 4 continents, so I have the privilege of studying many countries, and all what I see are similar, for instance, are similar ethical rules, which is backed by law, which could lead to your debarment, which could lead to criminal exposure, which could also lead you to civil exposure as a lawyer. I mean, one of the common denominator in the ethical rules in almost all the countries are that lawyers have to exhibit a high sense of candor, honesty, transparency. So now, if you are in the habit of going to copy and paste, going to use AI to write a paper or write a brief and submit it in court, you are likely to run into serious problems, because it could even lead to your being debarred. I mean, there are news reports in New York of lawyers using ChatGPT and citing wrong cases, and that's a serious misconduct, especially based on the rules in New York. It's serious misconduct which could lead you to being debarred. Because you see, as a lawyer, you are held to the highest standard of transparency. For instance, even if a client tells you XYZ, before you relay that information to another party, you have to check, verify, and believe that it's a fact. Because if you say, oh, my client said this and that, you will be held responsible if it turns out that your client's assertion is false, because you are the one we are holding responsible. So you see, there are so many layers of interest that law students should be aware of, that this AI is a good tool, but it's also, it can lead you into a place where it could be uncomfortable, especially if you don't know what to do, how to use the AI. I mean, AI, in all the LLMs you are talking about, I mean, the large language models, also conflicts with the basic law of copyright. Copyright, and like all intellectual property, grants you exclusivity powers, meaning there is economic benefit And also there are social benefits. Economic benefits meaning that nobody can use your work without your permission. Nobody can reproduce your work. Nobody can copy your work. Nobody can derivatively use your work, meaning they can't use your paper to turn it into a movie. You can't use your writing and turn it into a cartoon, a graphic. They can't use to turn it into music. So now, if you use somebody's work in the guise of educational purpose, without knowing the limits, without knowing the parameters, without knowing the core cases that governs that, cases like in Europe, InfoPac, like in America, Fiest publication, like in India, the case I just mentioned to you, D.B. Murdoch. If you don't understand what the case is saying, how much you can use, the laws of attribution, the laws of transparency, the laws of moral rights, which are very, very significant in the global south, which I am recently been focusing on. Because in the Northern American hemisphere, moral right is not a thing. It's not yet a big thing, but it's a big thing in the global south. In India, in Nigeria, in Saudi Arabia, moral rights is a big thing. And you could be exposed to serious civil liabilities if you copy somebody's writing and it goes against, especially his moral right of attribution of paternity, his moral right of you defamed or you use his work, for instance, his drawing, in a derogative manner, in an unethical manner. So lawyers have to understand that and don't allow the ease, the cheapness of artificial intelligence to now make us fall foul of this situation. Now, as I'm closing, I'm going to talk about how important legal writing is. Legal writing in the age of AI is very important because the traditional legal writing has been disrupted because machine learning tools and artificial intelligence has now kind of shifted the boundaries of the jurisprudence of even plagiarism. Now, even literary requirements of what is supposed to be your work. Now, the argument is going on now whether what you used, whether when you use AI to write a legal paper or any paper, whether that work belongs to you, whether you actually own that paper. Now, the Copyright Office in the United States, as recently, like yesterday, they've issued part 2 of guidance on when AI, the use of AI, could be accepted in a work. I'm sorry, my it's frozen. Can you run it from that side? I don't know. I can't move it here. Something's wrong there. But I'll send you don't worry about it. I'll send you the slide. I'll send the slide. I heard somebody told me it's frozen. I'll send the slide. I've already sent it I'll send it to you. But just listen to me. Yeah.
Okay, sir.
And now, if it's technology, that's the problem we have with it. That's why you shouldn't rely too much on AI when you are writing. So now, like I was saying, the problem of whether AI is an author or an owner of copyright is still being litigated in courts all over the world. But as we are right now, as you are there in India, we all know, if you are students of IP, that no country so far, in all the laws that I have seen, that copyright is only available, the ownership and authorship of copyright is only available for humans, persons, not non-humans. So that is where the law is at the moment, until something changes. But the law at the moment says that A machine cannot be an author. A machine cannot even own any IP, whether patent or trademark. That's where the law is now. So you see now that when you use too much of, when you use whether not too much, because we don't know what is too much right now. If you use an artificial intelligence tool, whether it's a generative AI, whether it's a predictive AI, even if assistive AI, which is the small ones we used, spell check, I put those ones in the category of assistive AI, spell check, formatting. In my opinion, those are not the problem because those are not consequential as per the quality of what you are doing. But we are more interested in the generative ones and probably the predictive one. I'm not going to talk about predictive because that's another subject. But we are talking of the generative one, the ones that helps you to create your literary work, your legal writing. So those are the contending issues that you should be aware of, that as long as you know that writing any literary work is just the modicum. It's just like your court in India said in that case, and even in the first case, it's you don't need too much effort for copyright to protect your work. So writing a legal article, an essay, an assignment, as long as the court have said, as long as it comes from your own selective ingenuity, what American court in the first court says, creative selection or selective creation, what the European Court of Justice, the Court of Justice of Europe, European Union, what they call in InfoPac, the author's intellectual creation. Now again, on other courts, like instance in Saudi Arabia and the laws in Saudi Arabia and the laws in Nigeria, they talked about sweat of the brow. But in all this jurisprudence of how to measure originality, you realize one thing is important, that the involvement of the human person is paramount. So probably as we await the court to tell us what is really, when and how ChatGPT and the rest of the AI systems could become authors or could become owners of creation. Remember that what you are copying, what you are using, still belongs to humans. And you might be sued if you defile or if you infringe on people's originality, people's copyright. So I will end at that, and I expect question. I think I went a little bit above what I wanted to do, but all what I can say that we are still moving on. The systems are evolving, the laws are evolving, and hopefully you as coming scholars and professional lawyers will be the ones to guide our economies, our countries on the proper way to go in terms of creativity. Thank you so much while I expect discussion and questions.